Hello everyone, I am Mahima Tulsian from ASC Group. I am here to throw some light on liquidation under Insolvency and Bankruptcy Code 2016. First and foremost, let us understand what is liquidation. Basically, liquidation is a process of bringing a business to an end through selling its assets. Although the motive of Insolvency and Bankruptcy Code was to revive the company, but there are some instances where the corporate insolvency resolution process is not successful and it leads to liquidation. But how this liquidation is initiated? There are certain circumstances under which liquidation can be initiated, such as the resolution plan was not received during CIRP, the resolution plan was received during CIRP but was rejected by a committee of creditors. The resolution plan was received during CIRP, approved by committee of creditors but was rejected by National Company Law Tribunal. The resolution plan was received, it was also approved by National Company Law Tribunal, but the resolution applicant failed to implement the resolution plan. Also, if at any time during the CIRP, COC decides to liquidate the company, then the liquidation can be initiated. Under IBC, liquidation can be classified into three types: sale as going concern, sale as non-going concern, and compromise and arrangement. Let us first understand what is compromise and arrangement. Where there is an amicable settlement between the promoters and the creditors, where the promoters give some amount to the creditors to resolve the corporate debtor within 90 days from the liquidation commencement date, is compromise and arrangement. However, when we talk about sale as a going concern and sale as non-going concern, it basically means that when we sell the business of the company, जब हम पूरा business company का या company as it is sale करते हैं कि उसका business चलता रहे आगे भी, जो भी उसे खरीदता है वो उस ongoing रखे, then it is sale as a going concern. However, जब कंपनी का बिजनेस को या कंपनी के असेट्स को हम पीस मील बेसिस में पार्ट्स में बेचते हैं, से फॉर एग्जांपल हम प्लांट एंड मशीनरी अलग बेच रहे हैं, लैंड एंड बिल्डिंग अलग बेच रहे हैं, या फिर सिक्योरिटीज एंड फाइनेंशियल असेट्स को अलग अलग बेच रहे हैं सब चीज़ों को, देन इट इज सेल एज नॉन गोइंग कंसर्न. Also, sale as a going concern has to be completed within 90 days from liquidation commencement date. But sale as a non-going concern has to be completed within 1 year from liquidation commencement date, and it is also extendable for another 1 year. The liquidator is vested with some powers and duties, such as making public announcement for calling of claims, verification of claims, taking custody and control of the corporate debtor, constituting stakeholders consultation committee, inviting bids and conducting e-auction, handing over the physical possession to the successful bidder, then distributing the sale proceeds, and finally making the report of dissolution to the adjudicating authority. There are certain reportings to be made by the liquidator to the adjudicating authority, such as preliminary report, asset memorandum report, sale report, progress report, minutes of the stakeholders consultation committee meeting, and final dissolution report. While the preliminary report and asset memorandum report are to be submitted to NCLT within 75 days from the liquidation commencement date, but the progress report is to be submitted to NCLT within 15 days from the end of each quarter. The liquidator shall make sure that while submitting the minutes to the stakeholders, he must take the undertaking from each stakeholder. A major role that liquidator has to play is constituting the stakeholders consultation committee, that is SCC. Our code specifies different class of creditors, and for each class of creditor, a representative has to be appointed. For secured financial creditors who have relinquished their right, if the admitted claim amount is less than 50% of the liquidation value, then maximum 2 representatives are to be appointed. If the admitted claim amount is at least 50% of the liquidation value, then maximum 4 representatives are to be appointed. For unsecured financial creditor, if the admitted claim amount is less than 25% of the liquidation value, then maximum one representative is to be appointed. If the admitted claim amount is at least 25% of the liquidation value, then maximum two representatives are to be appointed. For employee and workmen, one representative is to be appointed. For government, one representative is to be appointed. For operational creditors other than the workmen, employee and government, if the admitted claim amount is less than 25% of the liquidation value, then maximum one representative is to be appointed. If the admitted claim amount is at least 25% of the liquidation value, then maximum two representatives are to be appointed. For shareholders, one representative is to be appointed. The liquidator has power to take decisions, but there are some matters on which consultation of SCC is required, such as appointment of professionals and their remuneration, mode of sale, manner of sale, pre-bid qualification, reserve price, marketing strategy, and earnest money deposit. For a successful sale, the liquidator has to prepare marketing strategy, which shall include advertisements, information sheets, liaising with the agents, and sale notice. Sale notice is a very important document which is supported by e-auction process document. The sale notice and process document shall include date of auction, pre-bid qualification, reserve price, and the earnest money deposit. The sale notice is to be published on the website of the corporate debtor and on the website of IBBI as well. These are to be shared with the prospective bidders, and thereafter are the important documents on basis of which the prospective bidder shall submit their bid with the liquidator. Once the liquidator has identified the successful bidder after conducting e-auction and after receipt of sale proceeds, he shall hand over the physical possession to the successful bidder and shall distribute the sale proceeds to the creditors within 90 days from the receipt of the sale proceeds. When the corporate debtor is totally liquidated, he has to make an application to the adjudicating authority for dissolution of the corporate debtor. The adjudicating authority, on the application made by the liquidator, can order the dissolution of the corporate debtor. At last, the liquidator has to intimate the registrar of companies about such dissolution of the corporate debtor by filing Form INC 28. This was all about liquidation under the Insolvency and Bankruptcy Code 2016. Hope you liked our video. If there are any queries, you may write it down in the comment section below. Hit the like button and share with your friends and colleagues. Thank you.